ANI versus OpenAI is only going to answer questions related to the facts raised in that case,
Correct.
copyrighted works involved in that case, and legal questions that arise around those factual aspects. I think we have to be very, very clear about that as we close that segment. Now let's come toward India. Now, here's something that I want to really emphasize. India has actually been active, and I'm going to come to the policy enforcement part in just a second, but I want to set out the context. When we look at India's involvement in AI, India has had the national strategy in 2018. We had the responsible AI principles of the Niti Aayog in Feb 21 and August 21. Feb 21, the principles, August 21, the sort of how to act on those principles. And I've been working in AI for about 4.5 years. At that point of time, and I can say this with certain element from where I'm coming from, when we talk about the concept of ethical AI, right? People tend to talk about AI ethics. They look at it from a fungible concept. They look at ethics as some ethical, moral aspects of society. But the way I see the space, and this ties to how India sort of shaped this, is that from my lens, if AI ethics appears abstract to me, then in one sense, the responsible AI principles, though they are still at a principle level, the responsible AI principles published by Niti Aayog in 2021 at least give me a articulation of what AI ethics should look at a principle level. Those principles are principle of transparency, accountability, safety, privacy, you know, fairness and non-discrimination. And I mean, these are still principles, but at least I have an understanding. So that's point two, that we've had the national strategy in 2018. We've had the RAI principles in 2021. We also had then we've had a fair number of voluntary frameworks. ICMR has published one. The Telecommunication Engineering Center has a bias assessment fairness standard. We have there's a robustness standard from TEC. We also have NASSCOM sort of NASSCOM had an RAI toolkit that came out in October 22. They had the responsible guidelines for generative AI that came out in June 2023. We have the developers playbook for responsible AI, which was published last year, which is sort of an actionable step on how to practically and actionably achieve responsible AI. We articulated an AI life cycle, which is 4 stages of AI development. We conceptualized 3 types of AI in that: discriminative AI, which we just spoke about in the previous segment on pattern recognition tools; generative AI, which is AI systems that generate content; and then we have AI applications, which build on top of discriminative AI and build on top of generative AI. And in one sense, sometimes people say that India focuses on the application layer. And across these 3 AI types and across the 4 steps of AI life cycles, in those 12 silos, we've identified actionable risk mitigation prompts. And this entire playbook is addressed towards a developer, a technical person working in an organization, irrespective of whether the organization is an actual developer, deployer, end user. That's immaterial. But we're talking about responsible AI at the grassroots level, right? These 3 points, these about these voluntary principles, is to give our audience a context of where do we stand in terms of actually putting out frameworks out there in terms of guiding how this has to be done. This will now bring me to your second point about gaps, or where do we stand. There is a fundamentally, I want our audience to think about AI, and Madhav spoke about ethical guardrails. I want us to think about it slightly differently. For us to build responsible AI, for us to build guardrails, and particularly most of us are lawyers here in this room, presumably, we have to think of AI governance as a law plus track. AI governance in. So first we have this concept of responsible AI. Now, the principle of privacy may map onto data protection laws. Principle of security may map onto some aspects of data protection laws, may map onto information management system aspects in like ISO 27001, or may map into some information privacy management aspects. When we talk about accountability, you could have consumer protection laws. If I talk about actual laws, you could have, from an accountability standpoint, or from trying to understand how do we act in this space, you will have intellectual property laws that will cover it. Madhav spoke about product safety. We'll have consumer protection laws that may apply to it. We may have the IT Act that you spoke about it, right? So when we talk about governance, it's very important. So first, I had to understand what India had done. My second step in to answer your question is to know what laws do I have, and do I have the correct understanding of applying those laws to AI. And then to apply laws to AI, I have to be very clear what is AI actually, right? And one component obviously that's spoken of is data, right? So that gets covered in DPDPA, or there's product safety that goes to consumer protection, and using IP disputes. What about other than these 3? Then we have to get into this aspect of the plus component. The plus component being, let's take some example of concepts from the EU AI Act. I mean, we're not following that, but let's the EU AI Act has conceptualized risk management, Article
Right.
9. They've conceptualized the concept of human oversight. They've conceptualized the aspect of human oversight, risk management, explainability, transparency they in that one on general purpose AI models chapter they have, which is fundamentally equivalent to sort of some sort of Gen AI aspects. They talk about perhaps some disclosure, some summary data aspects. Those I'm not getting into the debate whether those obligations are right or wrong. To address the gaps, to balance innovation and regulation, it's really important for us to first conceptualize and understand what are the conceptual topics beyond existing laws that I can agree to technically or from an AI system perspective for us to really understand what the gaps are, right? So if we talk to and I would appreciate a follow-up question in this interaction, but when you're talking about where we stand, we've had a series of current laws and voluntary frameworks in the Indian context. We have the India AI mission, of course, which has 7 pillars, which of course there's a safe trusted AI pillar, which is more on the governance piece of it. There is on app development, there's on compute capacity. So there's work happening in that space as well. When we're trying to understand our picture from the international lens, there the context is very important. We need to be clear in what context are we talking about. Are we talking from a compute capacity perspective? Are we talking it from an AI governance lens? Because if we talk from an AI governance lens, then in my mind we already have a set of voluntary frameworks and current laws. And if supposing let me explain this. Let's assume voluntary frameworks are here and current laws are here. This is the gap. Right now someone would say that I want a law here, at this point where my finger is. But then for me to have a law at this point of time, I'm extending current laws here. So I'm going to extend the current laws to this point, or I am going to have some agreement as the technology is evolving that this aspect here can become a legal obligation. Till the
Correct.
point I don't have agreement about the fact whether this technical aspect between voluntary frameworks and current laws, if anything, because voluntary frameworks will be beyond laws. That's why they're voluntary frameworks in the first place, right? Because they're not, because if they were equal to laws, they would naturally not have any value, right? So it's a question of how proactive the person looking to work in AI governance is, how much law plus are they looking to go, how much of current laws are they following, and in order to address the gaps, it's important for us to understand what that gap is, and do we have enough consensus to be able to articulate a law